thanking Agami.
I recognize the hoodie if it is that one. I should have also worn that.
Yeah, yeah, it's that one.
Okay, guys, are we good to go?
Yeah, whenever you're good.
Yeah.
All right. Green, just one. All right. We'll sort of begin till people are actually joining in, and we'll talk about what the podcast is about. Um, I can hear myself in this. Just give me one. Yes. So, good evening, everyone. Thank you to Madeeha and Varun for joining us today. And I think it's a very relevant conversation that we need to have because over the last few years, artificial intelligence has gone from being futuristic and just a concept to people from being everyday interaction for citizens around us, whether it's something as simple as drafting emails or just translating into various languages or analyzing large volumes of information or creating content. It's just become a part of our lives, I think. And um, at Civis, we are obviously also leveraging um, AI in a way that democracy can be leveraged in a way that democracy can reach the right kind of citizens, and citizens that are not ideally uh, getting the benefits of the democracy, from helping citizens understand complex policies and consultations in an easier way to making information more accessible, um, by translating into various formats, various languages, and just increasingly, AI has given us so much potential to make sure democratic participation is more exclusive and accessible. But as these tools become capable, it's also raising a lot of important questions. Can it only assist us, or the human angle also becomes a firm in charge of it, and how much are we letting it in on our private lives, how much rights are being protected, how fair is it, and all of these relevant questions. And then of course there are a few institutions like the Supreme Court and the judiciary and the entire justice system, um, are also obviously affected by AI. And that's the conversation that we want to have today. So, earlier this month, the Supreme Court of India has released draft regulations for use of artificial intelligence in courts. And it's inviting stakeholders and citizens' feedback on the consultation. And it was a very good morning today because the Supreme Court has decided to increase the deadline of the consultation to 15 July. So that gives us more time to sort of reach more people, tell them what the policy is about, reach litigants who are on an everyday basis using AI to their advantage, and also letting citizens know how they may be impacted by this. So very excited for today's conversation, and I'm very honored, honestly, to be speaking to both of you all, because I was reading about your work and it's so interesting. Because we have, of course, Madeeha, who is, as she was mentioning to us before, that she is an advocate now practicing in the Jammu and Kashmir High Court, and a legal and human rights professional whose work spans from justice and international law and legal innovation across the world in US, Middle East, and North Africa, Asia, and Europe. And her work has focused on how legal systems can become accessible, accountable, and responsive to people's needs. And most recently, she served as the consultant to Agami on OpenNyAI, and I'm very excited to know more, because I think both of you all have been brainchilds to this project. So very excited to know about that as well. And is a justice tech. It's a justice tech initiative exploring how AI can strengthen India's legal system. We also have Varun, who has been very enthusiastic about this live. So, who is a senior curator at the Public Collective for Avoidance and Resolution of Disputes, again an Agami initiative, which is working to transform India's dispute resolution experience through process design, open source tech, and judicial change management. And his work spans court tech deployment, field research, and strategic engagement with high courts across the country. And before joining PUCAR, Varun led the OpenAI mission at Agami, one of India's most ambitious efforts to explore how, like I mentioned, leverage AI and frontier techs to improve access to justice. So, thank you both of you all for coming in today and helping us understand this very complex but relevant conversation for today. And both of you have worked on initiatives that sit very close to the question of tech and justice. So whether it's through legal AI, or access to justice, or building tools for people to navigate through the system. Before we get into the draft itself and the consultation itself, what has your work taught you about tech that can actually help people navigate the justice system, and where should one be careful when they are dealing with both the things?
Madeeha, you want to go?
Varun, you go ahead. I'll jump in.
Okay. So, thank you so much for that introduction, Sukirat. It's a pleasure to be here. I, when we started looking at AI in the law and justice space sometime in 2021, this was, before ChatGPT had come out. I think one of the things that we recognized was that AI really does have the power to potentially transform the law and justice field. And the reason we felt really strongly about that is AI is best applied to a knowledge domain, which the legal domain very much is. But the challenge at the time was that AI, of course, takes a lot of capital, it takes a lot of data to be able to train AI for very specific tasks. And in India, we just didn't have the data regime or the kind of capital that we needed to get to that point. So we recognized very early on that we really need the entire ecosystem to come together, to collaborate, to bring the kind of resources that you need to shape the kind of AI that this field really needed. And then, of course, ChatGPT came in November 2022, and then suddenly all of us had to rethink, how quickly AI was going to penetrate. We were thinking AI would take maybe another 10 years for it to, penetrate the Indian legal system. How wrong we were, both for good and bad reasons. And so I think, where we are today is we really have two pathways ahead of us. The way I see it is that there is this sort of default AI pathway that we could end up in if we don't really consciously take agency of the situation that we're in and start shaping how AI is adopted as an ecosystem, not just within our institutions, but also as individual practitioners. How are we using AI? Because today, everybody has access to AI, whether the court is leveraging AI or not. Every stakeholder within that court is leveraging it on their person. So right from judges to lawyers to litigants, all of them are using some AI chatbot for some part of the legal process or the other. So the question is, do we want to land up in an AI by default sort of situation, or do we want to shape how AI is used in what contexts. How do we make sure that it is done in a responsible way with adequate disclosures? And I think in that context, this particular policy paper was very timely. It was also very surprising because we're not used to large institutions, particularly the court, um, almost embracing an innovation-first approach to AI. Traditionally, the courts have been very reluctant to adopt any kind of technology. They're usually the last adopters of any tech. And depending on which side of tech you sit, you may think that that's a good or bad thing. But I think from a practitioner, I don't come into this as a policy expert, but as a practitioner, there are some encouraging signs in this policy of the sort of shift and signals that the court is sending. So we're taking that almost at face value, but there are also some concerns. I think even within the large sort of canvas that the Supreme Court has drawn in its policy paper, there's still a lot of room for detailing. And I think it'd be interesting for people to spend some time with the AI policy and see where we need to really spend more time almost shaping how this technology is going to be used, because right now the canvas that's been drawn is very, very broad. So that's, I think at this stage, even I'm sort of making sense of what this means, because a lot of our work with courts has gone through temperamental stages where, when we first went into courts, showing them technology, a lot of it was sort of cautiously enthusiastic. It very often takes years for courts to get warmed up to the idea of embracing even rudimentary technology, forget about AI. And now we've suddenly seen a shift in attitudes where courts are literally hungry, and we are almost struggling to keep up with the kind of demand that we are seeing from different courts speaking to each other and saying, hey, you should speak to these vendors or you should speak to these ecosystem players, and they might be able to help you adopt AI in a particular way. So I know that there's suddenly been in the last couple of months, huge, even in the run up to this policy, many high courts have released their own individual policy papers. Many of them are in the process of releasing their policy papers. So very clearly, something has shifted in the entire field. And for people like me who've been doing this kind of work, we're still kind of making sense of it. So, but I'd love to hear. Madeeha has been on both sides. She's been on our side of the field, and now she's on the court side. So it'll be interesting to hear what her experience has been.
No, thank you so much, Varun. And if I could jump in, I think I agree with a lot that Varun has said. But working with OpenAI and Agami, working closely on AI and access to justice in India for the past year, and also as the lawyer, I would say that the fundamental question I feel around AI is that, firstly, I feel like it's a conversation for everyone. So, like AI, to think of it as technology is only for, technologists, developers, software developers. Now I feel the conversation has moved. So there is, I feel, an approach where we feel like it's a multi-stakeholder conversation. Everyone needs to be on the table. Everyone needs to discuss because it affects all of our lives in every way, right? One is that. And the second is that I an important conversation is also not just what is AI and what is it that it is doing, but who is building these tools and what sort of tools these are. I think this is a very fundamental question to ask in terms of, before we really jump into the policy and discuss that and unpack that. I feel like as a law, as a human rights lawyer, and as someone who's worked with tech, I want to know who's building the technology, what sort of technology this is, and how is it that it is going to affect my rights, right? One is that. And another important, I think, question at the outset is, if we look at India as a country, right, we have to look at technology and see, and any type of technology, and I'm not just talking about AI, and see whether it is something that will, promote access to justice or build the digital divide. So we have to look at India as a country where maybe the digital literacy, maybe normal literacy is not the same at par, across the country. So if we go with an approach that we adopt such technologies, is it really going to, bridge that gap, or is it going to further sort of broaden that divide? So those are important conversations to be had around tech. But also, I feel like this is an opportunity for courts to sort of strengthen the trust in public systems, right? strengthen the trust in justice systems, because there is sort of the sentiment that has been going on, delays at the courts, कि ये तो अभी चलता रहेगा तारीख पे तारीख. It is also something that I see at the courts now that I'm working as a lawyer. But maybe this is an opportunity to change that scenario, to change that reality. And so I feel like there is a big opportunity, but also I feel this is an opportunity and a conversation for everyone to be had. And I'm also glad that we are having this conversation in that sense. Yeah.
No, but the fact that both of you all had very similar points about what's leading up to that sort of AI being built for such a system, right? And Varun, for you, you've worked on OpenAI, NyAI, and you worked on actually what it takes to build an AI for the legal system, right? So maybe if we could explore what are the sort of design choices or some sort of safeguards that one must make sure are enabled or are ensured while building such a legal AI tool to make sure that we are not just maybe talking about the safeguards, or maybe we do not have just an impressive demo, but we're actually leading up to something and which is genuinely reliable and responsible in practice as well.
Yeah. No, that's a great question. I think the first thing that we want to make sure that we're doing is we're not building AI systems that become dependencies within a court, right? Tomorrow, if the AI fails, the court should still be able to function. And so we really, at least at this stage in sort of the journey of adopting this kind of tech in a court context, we're always looking for small little um, tasks that can be taken up by AI, which maybe in the larger scheme of things, very administrative and kind of meaningless in a legal context, but huge in terms of being able to push the efficiency of the court forward, right? So I'll give you maybe one example, or I'll give you one or two examples from some of our work. So one of the things that we are in fact at the moment testing out is whether we can dramatically bring down the amount of time it takes for a litigant or an advocate to file a case, particularly for Section 318 cases, check bounce cases. Today, on a system that we have built, which is already better than, let's say, paper filing, it takes about an hour to finish entering all of the details that you need to enter, upload all of the files that you need to file. And this is assuming that you already have all of the data handy at the time that you start your filing. The reason it takes so long is because very often the data that you have to put into the fields already exists in the documents that you're already uploading, right? So for example, in a check bounce case, you're uploading the check, you're uploading a check memo, and so on and so forth. Then you have to enter a bunch of fields where it asks you for the check number, the bank name. All of those details already exist in the document. So one of the things that we're trying to do to speed up filing and bring down the time by half is just extracting all of the data using AI from the documents that you've already uploaded and pre-filling some of the form fields for you to then inspect. So that brings up another interesting principle, which is we could have just pulled the data and submitted it, right? But you want the user to be able to review, and they take an action that you can record to then submit that information on their own. So that's one example in terms of sort of almost an administrative process of data entry that you can use AI for. So we look at a lot of these sort of simple functions that end up just taking a lot of time because just the sheer amount of human labor that goes into it. But we don't want to eradicate the person or the role of the person who's currently performing that role. We just want to speed it up for them. So like this, if you look at the entire process from filing till disposal, you'll realize there are at least 20 different things like this, where instead of something taking an entire day sometimes to process, you can actually finish it off in an hour with a little bit of support from AI.
No, but that's a really interesting use case and really interesting point that you brought out. But it makes me question and also echoing what the general public must be thinking. And we've heard this sort of things, right? Like AI being used in courts, matlab now AI is the judge and AI judges and robotic judges and all of that. But I think it's a very relevant fear for the citizens as well, because it's very easy to become biased, and it's very easy for a system to get influenced as well. So maybe Madeeha, if you could help us understand in practice, where do you think that sort of assistance is ending and that human influence is being used and leveraged to make sure that such fears are not being um,
No, most definitely. I would say that echoing what Varun was saying, that there is a lot of scope to help with, administrative tasks or, technical sort of aspects. For example, case management and maybe translation tools. Varun and I and our team at OpenAI, we were working for a brief point on this translation tool. It was called Nyai Setu. And it had a lot of scope while we were working on it. So this was also an AI powered sort of tool that we were working on. But while we were working on it, I found that, it had potential in the sense that it could help translate documents, and there are so many languages, and AI is actually becoming good at that. For example, here in the J&K High Courts, there are various sort of documents, land records, which are in Urdu and also in the sort of Urdu that no one reads currently. So you need to have a very specific person at a very specific time. You have to go and submit the documents. And even every day at my office, I see like we have to call a person to read because nobody reads that Urdu, right? So there is that blockage. And this is something that technology already helps with across the world. And this is something that technology can help with. So translation and maybe redaction, things like this, administrative tasks, maybe technology and tools can help with. But when you mentioned the cautious line is actually that, um, like you said, is AI judging? AI is not judging, but I'll tell you my experience sitting at the court. So the other day I was just sitting at the court and there's a lawyer sitting next to me and he just has to present a case. And I think maybe he was just memorizing and he opened ChatGPT and he's like, give me this section with case laws. And I'm just looking at him 2 minutes before thinking, oh, so, there is this to me at that point of time as a client. I feel there's also transparency that is needed there. One is that usage in courts, honesty to say that I used AI for my research. Very recently the JNK High Court a couple of days ago also sort of gave in one of its judgment, there's this Justice Nargal, and he was reading a judgment and he saw those citations were hallucinations. So basically, he couldn't find those case laws, and then he sort of went, that there's a need for human review. One is that end, but another, I would say, why I'm giving these examples is I feel like we're moving towards this sort of automation bias, as they call in technology, which basically means you would think if something is automated, so it's correct. So you'd think if ChatGPT is giving me an answer, oh, it has done abundant research, it has a lot of resources, so this answer must be correct. And you end up thinking of those things. So what if judges also start thinking like that? What if judges take up cases and they're like, summarize this judgment for me, give me important dates, things like that. Tell me what are the five arguments that are being used. I'm saying this is a huge possibility if they're not doing it already, but there's something that they can do. So one is that uh, to sort of have those guidelines, but also have this transparency where if a lawyer has used AI to come forward and say, I have used AI for this, and this is what I've used for, and to have to draw a certain line and say, no, a judge needs to read all of this and, analyze it and adjudicate it. So for adjudication, we will not use AI because here is a question of, rights, parties, duties, things like that. So this is one. And another also that they mention in these guidelines is the citizens' choice for review. Like if you think, I'm this is very hypothetical in the future. Let's say we are using AI, right? And for any administrative task and you feel like your rights have been violated, then having a mechanism of being review this, maybe this because AI can also make mistakes, technology can make mistakes, so to have that sort of human review, as they call it, at each stage, I feel that is important. So there's a lot of scope, but in some places I feel, especially at adjudication, there has to be a little caution that we take.
Can I just add something?
Yeah,
Yes.
sure, Varun, go ahead.
Okay. So, I think sometimes the risk of the kind of AI, for example, that vendors and companies that are working with courts officially are
Hmm.
setting up with these courts, the fear of how that is going to be adopted sometimes is overblown, right? Because there's a high, I mean, what are we talking about? We're talking about an institution that is teeming with lawyers, and the smallest infraction of someone's rights will immediately blow up within the court. And I have
Hmm.
seen it, forget about AI. Like I have seen, for example, in Karnataka, they had adopted this private video conferencing tool very similar to Zoom. And so you could log into a court virtually. And one day the vendor created a feature where you could only log in when your case was being heard, but you couldn't view a case when it wasn't your case. It became a huge protest in the Karnataka High Court. They had to stop using that software until the vendor made the changes and allowed them, because they said,
Mm.
if I can physically walk into a court and observe a hearing, why should I be restricted digitally, right? So I don't think there is much of a risk, simply because there is so much scrutiny inside a court
Mm.
of officially adopted software crossing over these kinds of boundaries. I think where the real risk is where there isn't much oversight. And
Mm.
I have been in rooms with judges who very casually told us that, before I pass this judgment, I just wanted to know what ChatGPT thought. You know, so it is already being used
Yes,
in very
exactly.
subtle ways
Mhm.
by judges, by lawyers. And the funny thing is, if you read some of the submissions made by some of these parties, and if you developed an eye for seeing what kind of language AI typically uses, you can see which passages have come from what kind of AI, right? So it's already happening, but we're looking
100%.
in the wrong place.
100%. I agree with Varun in all of those submissions. And like we mentioned also earlier, that when we look at these systems, we have to look at, like it goes to that problem, like who's building it? And is this like a commercial sort of tool that we are building, or is this an institutional AI? Because I think then the checks and balances would be quite different. And honestly, I feel these guidelines have come, but AI is already here. It's in our lives, it's in the courtrooms.
Yeah, I'm honestly blown by Varun's anecdote, and I'm gonna think about it today because, yeah, I mean, we are all leveraging and using AI on a day-to-day basis to, like I mentioned, to even write an email. But to think about it, how it's impacting lives on an everyday basis, it's just, it's blown my mind. But we've honestly looked at how it's being used in courts and how it's used in the institution itself. But like we spoke about how Madeeha was mentioning, Tariq pe Tariq is a very common phrase that lawyers have heard, and people who are dealing with the system have been feeling and saying it out loud and voicing that courts need to become faster and need to deliver justice faster. But as an everyday citizen, as an everyday person, what are some of the use cases and what should citizens be thinking about in terms of this consultation, and as just in general as well, when they're dealing with the justice system, how can they maybe leverage AI better to deal with the system as well?
Why don't you go first, Madia?
No, I think in terms of how citizens should be using AI, they already are, right? They already are using AI, and it's already here. And I feel like citizens should look at AI with a lot of promise. Promise in the terms of, and I'm talking about, ethical systems and open source systems and systems that are built for this particular institution, let's say for the judiciary. I would say that there is a promise that backlogs, sort of could be cleared, a promise, as Varun was mentioning, for example, check bouncing cases, there are very time bound cases. So a promise that in a country as large as India, with millions of cases of one particular subject matter, that there is a promise that this could be heavily reduced, right? So there is that promise, and citizens, I feel, could look at it as significant in the sense that there is an opportunity to increase access to justice, right? So that is I feel a lot of potential that they can look at. But they also, I think, citizens would also have to look closely at, sort of what is it that AI then is also trying to do at the courts. As I also initially mentioned, that is it going to bridge the divide, or is it going to, like look at the digital divide that is already there in India? For example, I mean, I would talk about Kashmir and places across the country where maybe internet access could not be of the same level, for example, right? And then it also depends on sort of digital literacy that there is, and also what is the aim of the technology that you are sort of um, implementing. I read it in the guidelines. There was this particular regulation. Let me have a look at it. I think it was regulation 13 of this Yes, let me quickly tell you. Yeah, so Regulation 13 of these guidelines, where they talk about inclusivity and accessibility, and I like the line where it said that it would be deployed in the sense that it does not create or widen digital divides and is used for all stakeholders, including from rural, economically disadvantaged or linguistically diverse communities. So I feel the Supreme Court also acknowledges this, and I like that they've put this specifically there in these regulations, that this is for all citizens, not just specific citizens of specific state of specific state that could be benefited from it. So I feel like for citizens, this is there is a lot of promise and potential that could be explored. Varun?
Yeah. No, I completely agree. I think we should not expect that citizens will figure out how to leverage AI to better access courts. I don't think that consumer AI tools are necessarily going to make courts or justice a lot more accessible. Of course, if you're trying to make sense of laws, if you're trying to make sense of liability and things like that, chatbots might be very useful in sort of making sense, in terms of sense making. But the real opportunity is when the institution adopts AI to lower the ramp for citizens to be able to approach them. So, today, I mean, courts are completely unapproachable, not just because they're physically very often far away from where litigants are, but also because just the sheer, the almost intimidation value that the institution creates, that citizens, even if they had the capability, would not want to approach a court. But AI and of course the broader internet, by making almost thinking of the court as a service and making the court services available online, and making it easy to access those services regardless of what language, regardless of what disabilities you may have. For example, you may not be literate, but if you can communicate orally, can you have assisted AI technologies where you're able to talk to the court and be able to transact with the court just like any other litigant and feel no sense of that disability? So those are all the real sort of front-ending possibilities that AI offers to bridge the gap between between litigants and courts. I think the other thing it has a huge potential to enable is accountability, right? And I think there's a fine line because you don't want accountability to cross over into surveillance, but you want to be able to balance. Today, the court is a black box, right? And so very often you'll hire if you're lucky, you get a lawyer like Madeeha, but very often you may get a lawyer who's not really communicating with you the status of your case, or may not, or maybe either deliberately or for whatever reason, poorly communicating your situation and your position in a case. But when a court is able to reach out to a litigant directly, for example, just sharing the details of what happened in a hearing, either sharing the transcript or sharing a recording. Today, almost every court is recording its proceedings, regardless of whether they stream it or not. They have a recording internally. Just being able to share enough information with a litigant that they're able to feel like they know what is happening and that they're in control of their own litigation and not at the mercy necessarily of just an advocate. So there are many possibilities. I think when an institution adopts it responsibly, and the signals and the signs are there in the policy that the Supreme Court is thinking about these things. But like I said earlier, maybe the responsibility of those of us who were sort of evaluating the policy at an early stage is to do a little bit of the detailing.
Right. I'm obviously understanding that AI will help us ensure that we are reaching the people at the margins and making sure that we are providing that sort of access to justice by reducing that gap. But there's also this angle of empathy which is very crucial, and we always ponder about how we can make AI more empathetic and make the whole process more dignified. There is one thing about systems being efficient and faster, but there's also that angle of, are we thinking enough of the citizens? So maybe Madeeha, the fact that you're dealing with people on an everyday basis and you're dealing with people who are facing the system in a way that is not maybe the best, but how can we make sure that we are how can we make sure that we're accounting for that angle of human empathy when we're building such systems and leveraging AI to enhance such systems?
No, most definitely. I feel that is a very, very important question to ask at this stage. And not just for AI, like I say, for all technologies that we are building. If you look at these guidelines, and I was trying to read, that I was looking at it as a lawyer, and I was like, how many times are they mentioning human in it, like human review, meaningful human. But I feel like there was something that was a miss, was the guidelines do not really, explicitly say that the systems that will be designed will be also human centric. So, when you build when you build a model, you have to build a human centric model, and a model that is built to ensure protection of human rights, that is to ensure that it it serves everyone, and that it is built. Efficiency is of course important, but I would say a larger question at the heart of justice system, and especially India's justice system, is whether rights are protected of individuals in this country. So I feel like, to when we're building a system, and I like I say, like it should be given India's circumstances, and also because I have worked on this system, it should be like a community driven effort, in the sense that these systems that are built speak for the community, that is India. And as Varun mentioned in the beginning, that it is for the whole ecosystem that you are building it, right? So one that is very important. I was also, while I was looking at these guidelines, and there are some good points in this as well. They do mention the human in the loop part, and they mentioned, for example, that there is transparency, and that there will be an auditing that will be done. But again, there is an ethical impact assessment that these guidelines mention, like ethically, what is the impact before deployment, post deployment. That for me, I would say, as a human rights lawyer, I would rather look for a rights based assessment and not just an ethics based assessment, because ethics is a broader term, right? What is ethically, but I would look at it as a rights based assessment, to see whether that, as a system that you are building, if it could affect fairness, privacy, equality, things like that. And as Varun mentioned, that whether this could go into surveillance, for example, and what is, and then there are questions of the data that would be collected, a completely different conversation to be had. What will happen to that data? Who will, of course, the Data Protection Act also applies to this, but where will this data go? Will this ever be available to any private vendors? Will this go to this, for, let's say, to the state, for so this is something that there is a conversation to be had. But like I said, I feel like assessment of these tools would have to be from a rights-based angle. And also these tools, according to me, have to be human-centric and have to be around, have to be made also thinking not just how it will make the judiciary efficient, but how it will make the citizens, like Varun said, come to the court and, and work. I'll give you a working example at the court in J&K High Courts, and also in the lower district courts where I go to. So they've introduced like a app which wasn't there before, right? Court app, right? So initially I thought when I went to the court that this must have created, because these lawyers have been used to this or their old processes of reading a sheet outside the court and seeing what number comes and reading their cause lists. But through the app, I see like even like lawyers in their 70s, and all the others, and even litigants knowing what is happening. So they're like, my number is this is what happened in my last order, right? This was for hearing this is the stage of my proceeding. And as Varun mentioned, you see in the courts a lot of times maybe the litigant is misguided or doesn't know why my case is taking so long. Why is it taking 2 years? But now there is like a whole timeline that you can look at through the app. You can look at what the order was, when was it passed, whether your lawyer was present or not, which you may not have that sort of information earlier. So I would say that efficiency is there, but fairness and equality and also rights, and making those tools very human centric to these people who are coming to courts for justice, I would say is quite essential. Why don't you want to add something to it?
Yeah, just a few things. I mean, language is a funny thing, right? And it reminds me of the word responsible AI. So, AI is a technology built by people, and so the responsibility should lie with the people who designed it, right? But when we use terms like responsible AI, it's almost attributing some kind of sentience to the technology as though it is, we're almost evaluating the tech for having human emotions. That all technology, whether it's AI or not, is only as empathetic as the people who designed it, right? So that is why I think to me the fundamental question is not necessarily who designed it, but did everybody who's going to be affected by it get a chance to be a part of the process of designing it, right? Because any vendor or anybody capable of designing a system should design a system, but the question is everybody who's going to be affected by it, do they feel like they have a seat at the table? And if everybody is involved, and if the designer is empathetic, and if they come from a human-centric school of thinking, then whatever they produce will also be empathetic and human-centric. The technology has no capacity to feel, has no capacity for empathy. It merely encodes the empathy of the people who designed it. So that the question that you asked, who designed it, is a great question to ask. I was just expanded to, did everyone get a chance to design it?
Right. So it's honestly about who we are bringing to the table when we're building that AI and ensuring that all of these voices are being heard. But very interesting to actually dive down on that. And I'll slightly take us through to a more international approach, because obviously it's not an India only problem, right? Like AI is being actively used across the world as well. And if we could maybe discuss what are some of the models that maybe you both have studied to understand how we can leverage that in our justice system. And obviously we cannot compare ourselves to countries across the world, because our needs, as we mentioned, and our citizens and our communities are very different. But some systems that maybe caught our eye and could be used to deliver justice in a more efficient and fairer way.
I don't know, to be honest with you. We have spoken to people who are involved in projects in different countries, and I think the takeaway has been that I mean, of course, there have been we've read about instances, for example, in U.S. courts of AI being used in all kinds of interesting ways. And I think but overall, barring these outliers that were sort of quick to adopt AI and then have learned like some lessons the hard way and have sort of rolled things back, right now where we are, I think a lot of countries are sort of more or less at the same stage of running a few pilots and almost testing the waters of what works. But again, I'm not, I haven't done a thorough study of where everybody is in terms of their adoption of AI. But at least in the ASEAN region, the few folks that we've been in touch with, it does seem like um, India, in many ways, has run quite a few experiments, and they almost reach out to different ecosystem players over here. In fact, I know many ecosystem players over here who are offering services both in ASEAN as well as in the Middle East. But it's been too soon, too early to sort of judge, I think, the effect of some of these pilots. But yeah, maybe Madeeha has a better perspective.
No, I agree with Varun. If we look, there are few countries who have gone ahead, for example, and also have like their guidelines. Know that very recently UNESCO had come up with their guidelines on use of AI in courts and tribunals, and they had these principles, very similar to whatever has been adopted, but also, like I said, they looked at, what is like a multi-stakeholder collaboration angle, and what is it that when you deploy these systems, what is it that codes should look at. So very similar to they're also looking at rights, etc. But and then the US has their own act, and EU has famously their own AI act. And I read that last year while I was working on a project, and they sort of make these classifications on high risk areas, high risk assessments, lower risk assessments. So basically, they sort of do not allow use of AI in scoring, human scoring, which is, for example, give us, like, based on this, give me a list of, for example, you could say, like, looking at data to say, you could say, which is the area where there are more crimes, for example, things like that, to use these tools and data which could further entrench racial and socio-economical biases. So these sort of scoring systems, scoring individuals, and using these tools for surveillance, and using these tools are very high risk assessments, not to be used at all. So that is, those are some of the caution points that other countries are taking. But honestly, to learn from them, I would say that India is, as Varun mentioned, at a very at this vantage point where this is the first time, because earlier technology was always, like Western countries adopted it, and then it took us like 5 years or 10 years to adopt it. Right now, we are all at the forefront. So India is where all the other countries are, and I would not say maybe we are advanced in but the conversations are happening parallelly. And one important factor to see here is that you cannot copy paste any of these, their sort of, systems and guidelines and rules here in India, because there the legal infrastructure is completely different. The court system is completely different. For example, in the Western countries, or I won't say Western countries, but whatever other countries apart from India and the global north, you would see that, let's say, like a will probate case, like family case, would take 2 weeks. In India, it will take a year. So the process is different, the procedure is different, things that happen are different, and the legal system is very pluralistic. And I would say that is also the beauty of the system. We don't need like a uniform sort of system throughout the country, right? We don't need this country is diverse. The systems that work are diverse. So you cannot copy paste those here and say, okay, because in the West, in EU, they are using these sort of guidelines. Let's also use them here. So I would say that that is also completely different. So we have the opportunity to build something that is uniquely Indian, and something for the Indian, I would say, legal landscape. So that is the opportunity. And of course, there are some things to learn, the mistakes that they have made. For example, this surveillance and accountability. Where is it that you draw the line? But this is an opportunity that we start and build something of our very own, I feel. Varun?
Not much to add. I think the spread of innovation in particular when it comes to technology with courts has been very uneven in India. And that's true of everything actually, because if you walk into any court, like Sikkim, for example, which has a very low rate of pendency. In fact, they have very little filing. I think the High Court handles something like less than 300 cases in a year. So fewer cases than there are days in the year. They have a very strong tech team that builds phenomenal technology, uh, partly because they have a small number of cases. The risk of failure of that tech is very, very low. So they become a great breeding ground for all kinds of innovation. And in fact, one of the things that we've been trying to suggest is that courts that have developed this kind of capability, Sikkim is one that I'm aware of personally. Kerala is another one that I'm aware of that has its own IT team that's doing a phenomenal job, that's recently won a Government of India e-governance award. There are these islands of innovation happening even within the public system. And I think it'll be interesting to see how, and you see traces of that even in the AI policy, of how courts can start talking to each other and learning from each other, from all of these experiments that they're running, all the mistakes that they made in terms of technology adoption, how to build trust when you're adopting technology, because every court struggles. Particularly if you go to places like Karnataka, Kerala, you will find on the walls of the district courts protest signs put up by the lawyers over there, protesting against e-filing. They don't actually have a problem with e-filing. They have a problem with the fact that these policies have sort of crept up on them overnight, and that e-filing has not made life easier. It's made it worse because the court has not stopped the need for regular filing. So now not only do you have to file normally, you also have to e-file. So what was designed to be a convenience has now become a burden. But there are many courts that have figured out how to make the transition from paper filing to paperless. But if courts just spoke to each other more often, not just at a judge to judge level, but also at a court staff to court staff level, there's actually room for us to push some of this innovation forward a lot more responsibly, because there's a lot of intelligence already sitting within the institution.
Right. Very, very interesting points and a lot of food for thought for me also and everybody listening to go back and think about. But my final nudge would be for both of you all to maybe give one or two points for anybody who's listening or will listen to the live later. Um, they may be concerned with the justice system, they may be part of the system or not, or they may be just an active citizen wanting to respond to the consultation. What's the one or two things that are maybe alarming in the consultation, or are maybe points that you did not expect to be in as part of the draft guidelines, and like just sort of giving a direction to anybody listening to give what kind of feedback that they can give to the Supreme Court when they're making these sort of guidelines, to make sure that we're making a more comprehensive sort of guidelines um, to leverage the AI in the system. Uh, Okay, I'll just repeat the question for Varun. But my question was that I'll sort of nudge both of you all to help anybody who's listening, any citizen who wants to respond to the consultation that the Supreme Court has released. They may be part of the system, the justice system. They may not be actively part of the system, but just want to respond to the consultation. So maybe one or two points that you found that need suggestions or should be thought about when responding to the consultation, and can give a sort of direction to everybody listening when they're thinking about AI and the justice system.
Got it. Madeeha, you want to go first?
Sure, I can go first. As I mentioned earlier, I feel like the guidelines, there are many issues that they do cover, and there are many sort of angles that need to be filled in. There is promise, there is the scope for review that they have mentioned that the human will be in the loop, etc., etc. So there is also promise of transparency and accountability of these systems that will be built, and then I feel like in that sense, there is promise that litigants have a right to know what systems are being built for them and who is building these systems and who is designing these systems, and then whether they had a say in the designing of these systems. Because as I mentioned, there is a lot of potential, a promise to design something inclusive, design something transparent, and design a system that works for litigants that come. The only thing that when I was looking at the guidelines, I would say suggestion is that they are also there is this thing that they're creating is like a massive apex body that will look at and that will look at that will sort of dictate what will sort of what is the code and how all of this will work. Listening to Varun's last point, I feel like maybe there is also a need to give a little bit more autonomy in terms of budget, etc., also to high courts, because as he mentioned, different high courts work differently, right? So I feel like there is sort of here a scope to allow high courts to adopt and customize a model that fits best to their local realities and that fits their sort of ground realities. And also, I also feel like that it then speaks to the nature of our constitution, which is a federal. It's a federal system. So in that sense, there is potential then that these models, these tools will then work for those high courts, and we can each high court then can learn. So I would say that if an apex body is made, that it is not like a top down approach, that an AI system is built or adopted, then every high court has to follow that, whether or not it is true to their realities. But I would suggest that those local sort of courts also get to have a say in that. So I would say that would be my suggestion. But overall, my points remain the same, that it needs to have a multi-stakeholder approach, multi-stakeholder governance structure, and also these tools need to be built with that human-centric approach, and where rights are protected, and that is at the heart of these tools. Varun?
Yeah, yeah. Yeah, so there are like I think a bunch of sort of issues that sort of become self-evident when you read the AI policy. So I won't go into any of those. But the last thing that Madeeha spoke about, so this body that the policy sort of envisages, Today there's already a monopoly within the existing court system of NIC, right? And NIC being a government body, practically, so every court runs on something called CIS, the Court Information System. And, the challenge with CIS, at least this is completely my personal opinion, doesn't reflect my organization's opinions. But I think to me, fundamentally, the biggest challenge to innovation in a court has been the presence of NIC on multiple planes. One is, of course, that they operate a near monopoly in terms of tech within a court. And the challenge with a government agency building technology for another public institution is that the last person that they build for is the citizen. That they're very often building for people within the existing system, and those are the only people that they consult. And so when you look at CIS, you can tell why it's bad. You can almost imagine what kind of conversations took place for them for this to be the product that they've come up with, right? And this is a system that has existed within courts since 2011. The biggest thing that the court has done has been to signal that innovation can come from anywhere when it comes to AI. So it explicitly talks about what kind of frameworks to adopt and being in terms of being able to work with third parties and vendors. That's great, but we don't want to we don't want to jump from one monopoly to another. So what Madeeha said about what is the role of this body? Is it just going to be another dictatorial institution like NIC that then imposes technology on every other court? That'll be a huge disaster. It'll be just us replacing NIC with whatever this other institution is going to become. The same thing is true if it's not like there are 20 institutions in the country building technology for courts. There are probably like 2 or 3. And to me, the key question is, how do we make sure that this becomes a vibrant ecosystem of competitive players whose incentives are aligned with not just the court, but also the litigants? And that is a completely different ballgame. The AI policy is not solving for that right now because it has never been the court's strength to create a market. The court is not a commercial body, right? It doesn't transact with vendors except people who are selling them books to put in their library and stationery to put in their storeroom and things like that. Technology is very often just been a government to court play, or sometimes some courts have their own staff that do this. This is the first time that they're going to be creating a court economy for technology. And how that economy is created will define, and how the incentives are set up will define what kind of players enter and who becomes the new monopoly, if at all, or whether this becomes an even playing field where many different players are playing, and the winner at the end of that game is the litigant. So to me, that is an issue that's not very obvious when you look at the policy. It doesn't talk about this. So to me, when I look at the policy, I always ask myself, what is the policy not saying that we should make a part of the conversation? Because everything else is a red herring. And sort of the obvious conversation that everyone will gravitate towards. But some of these little things is where I feel like we may have regrets 5 years down the line that we didn't think of this better.
Right, and I'm hoping this goes viral and there's like some formal sort of demand that's being created to, have more competition amongst people who are making AI for the justice systems, because only then we'll be able to make sure that we are getting the best to the system as well. But thank you so much for bringing up that point, and thank you so much for both of you all to agreeing to, first of all, doing it at such a short notice, and secondly, to bring in such vast and diverse perspective to this conversation. And I'm sure we are going to be like enlightened is one thing, but also it will always help us give us a perspective of the policy as well, because obviously we at Civis do summarize and help citizens respond to the consultation, but perspective from people who worked in the domain always gets us more insights to this. So it was, yes, Varun, do you want to add something too?
Yeah, no, you just reminded me of something. If I'm not wrong, this is probably only the second or third time that any court, leave alone the Supreme Court, has reached out to citizens asking them for their opinion, right? And if I'm not wrong, the first time was when the Phase 3 e-vision, the Phase 3 of e-courts vision document had come out, and that tells me something, right? what it tells me is that the courts know that this is a huge moment, right? You can't frame these policies in isolation, which the court is very used to doing. Every other policy is framed in isolation. Citizens and litigants are never consulted. But the fact that they've opened up this AI policy to citizen comments, to me, is huge. It's historic. I think it's only the second time it's happened in the court's history, and I think it's going to be really important for citizens to show that they care about these policies by participating, talking about what they care about, sharing their concerns openly, because uh, somebody is listening. And tomorrow, this AI policy is not going to have an impact 5 years down the line. It's literally going to have an impact next month, a month after that, because just about every court is already piloting AI in some way or the other.
Right. That was a very interesting point because we make a part of the system, right? If we show that sort of interest and show that sort of enthusiasm to respond to these policies and giving our perspectives, is only when they'll be motivated enough to, you know, ask us what we feel about it. So thank you so much for being part of this conversation, and I am hoping that we have motivated enough people to talk about this and share it within their groups and respond to the consultation. So, hoping for more interesting conversations in the future. And thank you so much.
Awesome. It was
Thank
so good.
you.
Thank you, Sukirat.
Yes, thank you for having us. Had a great time. Thank you.